three forms of communication the Fair Debt Collection Practices Act makes illegal. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. The Fair Debt Collection Practices Act, FDCPA, is a source of many protections from ruthless debt collectors for people who owe or who allegedly owe money. As I often point out, what makes the Act so powerful is that, in addition to making certain specific actions illegal, the FDCPA also more generally makes any unfair, oppressive, or deceptive collection practices illegal. The focus of this video, however, is just three specific forms of communications designed to embarrass debtors. I've been doing a series of videos on the FDCPA. The point of that is to show you some of the ways the FDCPA acts so that you can kind of get a grasp of how it might apply to your situation. Okay, so 1. When debt collectors are looking for you. Under 15 U.S.C. Section 1692B, a debt collector who's looking for a debtor must identify himself by name but not mention his employer unless specifically requested. He cannot state that the consumer owes any debt, and he cannot communicate more than once with any person unless requested to do so, or unless the debt collector reasonably believes that the earlier response of that person was erroneous or incomplete, and the person now has correct or complete location information. This portion of the law was obviously intended to stop debt collectors from harassing and annoying the people around the debtor for purposes of damaging relationships or creating social pressure on the debtor. 2. Debt collectors cannot communicate at unreasonable hours. Collectors are not allowed to communicate with consumers at any unusual time or place, or at a time or place known to be inconvenient to the consumer. Unless a debt collector actually knows that the consumer has unusual hours, he cannot call before 8 a.m. or after 9 p.m. local time of the consumer, and that's 15 U.S.C. Section 1692C, subsection A. If you are being contacted at work, therefore, you should tell the collector that this is an inconvenient place and time for communication. It is also specifically illegal for a debt collector to call at the place of work if he knows or has reason to know that the employer prohibits the consumer from receiving personal communications at work. If you work a late shift, you should tell the debt collector what hours are inconvenient for you. It obviously makes sense to communicate with the debt collector in writing, but you don't have to, and to make records of any phone calls that you receive outside of the specified hours. 3. Debt collectors cannot communicate with third parties except under limited circumstances. Collectors are not allowed to talk to other people in connection with their collection efforts, other than as specifically allowed, that I mentioned above regarding finding you, unless you give your prior consent or unless a court gives that permission. However, they are permitted to talk to your attorney, a consumer reporting agency, or agencies, and the creditor and its attorney. The big exception to this rule involves post-judgment judicial remedies. That means that if the debt collector obtains a judgment, it may seek garnishment of your wages or bank accounts. And it is permitted efforts that are reasonably necessary to obtain these remedies. That's 15 U.S.C. Section 1692C, subsection B. This section is obviously designed to allow debt collectors to take the steps necessary to garnish wages and seize bank accounts after judgment. But I believe this section prevents debt collectors from harassing people who refuse to give them information about your whereabouts or to cooperate in other ways. That's because it requires efforts that are reasonably necessary, and if a person is refusing to communicate, then it's not reasonably necessary to continue harassing them. Again, the prohibition exists to prevent the wanton damage of a consumer's relationships with other people. Your rights under the FDCPA. If debt collectors are engaging in any of the above-mentioned prohibited acts, they are violating the Fair Debt Collection Practices Act. For information on what to do if that happens, please visit my website or consult an attorney. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.